We now have Bill Cox, who is a statewide expert on mental health and juveniles. Bill Cox received his bachelor's degree from the University of Texas at Austin and his Juris Doctor from St. Mary's University School of Law. Bill is board certified in both juvenile law and in criminal law by the Texas Board of Legal Specialization and is serving as the secretary of the juvenile section of the State Bar of Texas. He has been a member of the El Paso County Public Defender's Office since 1995 and serves currently as the first assistant public defender. Welcome, Bill.
Thank you. Good morning, Judge Wheelis, and I'd like to thank the Judicial Commission on Mental Health for the chance to come and talk a little bit about Chapter 55 and juvenile mental health issues.
Many juvenile practitioners are familiar with Chapter 55 in general, as it's well known to cover fitness to proceed and lack of responsibility. But that is not what we're here to talk about today. Is that correct?
That's correct. I want to talk about a different part of Chapter 55. And before we start to delve into it, I'd just like to get an idea of how many members of the huge audience we've got here today have worked with Chapter 55. So if we could go ahead and put up the first poll while we do a little bit of introduction into talking about another part of it, which is Chapter 55's subsection B, which does not deal with fitness to proceed. It only deals with children with serious mental illness.
Thank you.
And when we're go ahead, Judge, I'm sorry.
When we're talking about Chapter 55B, are we discussing serious mental illness and priority populations and the Big Four, or what are we specifically dealing with?
We're absolutely talking about serious mental illness. However, while someone may have one of the Big Four, schizophrenia, bipolar, schizoaffective, major depression, it doesn't necessarily have to be. We're really delving more into the realm of the health and safety code and the commitment criteria that would require an inpatient treatment rather than someone who can be treated out in the community.
And tell us more about Chapter 55B. In what cases and for what kind of kids and conditions and diagnoses have you yourself personally used it for? And I know you're going to want to protect HIPAA and attorney-client privilege of any previous patients. So let's use the name Jane for your case.
Before we go into talking about Jane, who is a perfect example of why the legislature created Chapter 55B, I want to clarify a little bit more and make it clear where we get to Chapter 55B. Normally, when we're talking about 55, we're talking about either juvenile fitness to proceed, which is the juvenile term for competency, or we're talking about juvenile insanity or lack of responsibility. For juveniles, the legislature created another option, which are children with serious mental illness that meet commitment criteria, but they may understand everything that's going on with their case. They may be able to consult with their attorney. They may be able to assist in their defense. And they may or may not have been completely sane at the time of the alleged charges. The big difference that we have here, as you see from the PowerPoint on the screen, is that we are only talking about, does the child have serious mental illness and meet commitment criteria? And in the case of Jane, we had a young lady who was very intelligent, suffered from major issues that did fall within the Big Four, was a significant danger to herself. And without having Chapter 55B, we may well have been dealing with looking at a very unfortunate end result on the case, which did not fulfill either the goals of the juvenile justice system or the health and safety code. And now's probably a good time to bring up our other poll looking at what would the options be for a child with serious mental health issues in a lot of the jurisdictions across the state.
What went into your discussion or your meetings that led you to the belief that you needed to file the Chapter 55B if it was you, and who can file?
In this case, it was Chapter 55B is very much like any of the other proceedings under Chapter 55. It can be initiated by the defense attorney, the prosecutor, or by the court. And in this case, simply because Chapter 55B is really sort of the zebra of juvenile mental health. It's not used often. I've used it probably 2 or 3 times total in my career. So I usually start with a regular fitness to proceed. If nothing else, then we get the full assessment by the mental health professionals. We get the diagnostic reports prepared, and it provides a foundation for the discussion with the court if, like in this case, as I was concerned, Jane was fit to proceed. And then following that, we start looking at other options.
So, are you able to see the poll results on who has had experience with the Chapter 50 use of Chapter 55 in the first place? You might want to talk a little bit more in depth about what goes into the filing of a Chapter 55. What are your thoughts at the time? What are your concerns? How is the family and the child presenting?
So, and it looks like if I'm reading the results right on the second poll, we've got about 8% in home and 15% out of home. So I suspect we've got a lot of, which is where we frequently end up on mental health issues. I have no idea what I'm going to do with this, how I'm going to address the concerns. And that's frequently where we end up with a child with serious mental illness. All too often, when a child with serious mental illness gets into the juvenile system, uh, it may be that the parents have been trying very hard to work with the child. It could be that the child's mental health issues manifest in danger to others and assaultive behavior. It may be danger to themselves. And they literally have run out of other options, and they're coming to the juvenile system asking, what are our options? What can we do? Sometimes they come from the Child Protective Services route, but frequently a lot of people feel like family members, caregivers, their options are exhausted. And frankly, the family is frequently exhausted. And in Jane's case, what will always stick with me was what came back when we did the assessment for looking at standard fitness to proceed, which is that one of the mental health professionals said, we've got to be creative to keep her alive at this point. She had had numerous suicide attempts. She had frequently voiced suicidal ideation. And this is really why I believe the legislature created Chapter B, which gets lost all too often. When you read it, you look at it and it's like, okay, so the child has mental health. We jump on to fitness to proceed. And the legislature recognized that if a child has such serious mental health needs that they meet commitment criteria, which is that they they have a serious and persistent mental illness, that they are likely to cause harm to themselves or others. They're suffering severe abnormal mental, emotional, or physical distress, and that their ability to function is deteriorating. They need to receive inpatient treatment. And this is not a child that should be receiving or in the real part of the juvenile justice system. Chapter 55B, and this is how it functioned for Jane, gives us an option to divert those children that the delinquent behavior is not the primary concern. It is not the area where rehabilitation is needed. It's treating their mental health as needed. And so it gives us the option to get that child into the state mental health system. And like Chapter 55, C or D, where we're dealing with competency or insanity, it also does what I have described as super priority population. This is not that the state's mental health facilities take the child once there is space that when you get there. And I know we've gotten much better than we used to be, but the language in Chapter 55B says that the state shall provide a placement. And that is so important for children who are in the level of extreme mental health danger that Jane was and any others who fit this criteria are.
In your case involving Jane, may I ask, was the offense a felony or misdemeanor? And can you discuss the relationship between those cases that you might choose to file that Chapter 55B?
Excellent question. And it was a felony. And this was after the changes in the Texas Family Code, where only felonies can go to what used to be TYC, now TJJD. And had we not had this option, because of much like we saw in the poll with some go home, however, frequently the home caregivers, when we get to this point, are not able to meet the needs or are already exhausted. And frequently, even a lot of the placements with RTCs are not able to meet the high level of care needed by a child who meets the commitment criteria. We probably would have been looking at a TJJD placement. Thanks to the options and the requirements of 55B, we were able to get her into long-term mental health treatment through the state. And I think, quite frankly, saved her life and gave her a chance to go forward and be productive in the future.
Thank you. And can you discuss your beliefs or theories regarding why would the legislature put this in place in terms of the two-pronged elements of juvenile law? Number one, community safety. Number two, rehabilitation of the child.
Well, and truly, this meets both of those prongs. One is, if you're meeting commitment criteria, you're a danger to yourself or others, first and foremost. And number two, when you're in the extremis that is required to meet commitment criteria, then really you need to be in an inpatient treatment environment. And I want to go to a question I just saw pop up from the chat that I think is a very important distinction to point out, which is, yes, Chapter 55 does have options for outpatient treatment, but those are for a child who is competent to proceed, not for a child who meets the Chapter 55B requirements. The really important distinction with Chapter 55B is this is a child who, were they an adult, we would probably be looking at a commitment proceeding under Chapter 571 of the Health and Safety Code because of their deterioration in their ability to function and their ability to care for others or their danger to self or others. Chapter 55B gives us that option for juveniles to meet the unique needs of kids and to divert them out of the juvenile justice system.
And can you talk a little bit about, I think this is a good segue, that question, about the burden of proof, the burden of also on the movement who files the Chapter 55B?
And this is one of the unique areas about Chapter 55 that, in the case of insanity, concerns me greatly because of the examinations which are performed for an insanity case where you're talking about the actual facts of the case. But whoever moves has the burdens, whether that's the defense or the prosecutor. It's a little more unclear if the court on its own motion were to initiate it. But the burden is by clear and convincing evidence to show that the child is in fact unfit, or in this case meets the commitment criteria, and that the child then, and there's another step to this which we haven't talked about, which is once you have the initial assessment, you find that the child is suffering from severe mental illness. Before you get to the commitment hearing under Section 571 of the Health and Safety Code, you have to have two physicians complete the certificates of medical evaluation, which must be done within 30 days of the commitment hearing. And then that commitment hearing can either be done in juvenile court or, depending on local practice, referred over to an appropriate authority, which would typically be the probate court in the jurisdiction.
And what are the presumptions that the judge must follow?
Well, the child, like any other presumption in Chapter 55, is presumed to be fit. In this case, is presumed to not be a danger. So again, the movement has the duty to overcome that presumption and show that the child is a danger to themselves or others, does have a severe and persistent mental illness, and that is experiencing deterioration in their mental or physical ability to function independently and needs to be committed for inpatient treatment.
So if I understand correctly, then when you analyze whether or not you're going to file a Chapter 55B, your main approach is to approach it as if it's a regular Chapter 55, whether it's unfitness or lack of responsibility.
I start from the standpoint of fitness to proceed. Lack of responsibility to me is similarly to the Chapter 55B issue, secondary. If they're fit to proceed, and I've got a child who is so severely mentally ill, like Jane, that I'm afraid they may not survive to get through, that they need inpatient treatment. And there's another part that we haven't talked about, but typically when you have a child who has the severe mental illness we're talking about in this case, they don't need to be in juvenile detention either. And typically that's where they're going to be while we're going through the process. They need to be receiving inpatient mental health treatment. And that's the environment that's most conducive to their rehabilitation and to help them succeed. The other item that I probably should point out is Chapter 55B is only for severe mental health issues and does not apply to intellectual developmental disorder, unlike a standard fitness to proceed or lack of responsibility.
They can be comorbid, but that cannot be the primary basis. And what happens to these cases? For example, in Jane's case, did that stay in juvenile court, or did the court refer their juvenile court jurisdiction to the probate judge?
It stayed in juvenile court and ultimately was diverted completely out of the juvenile court and over into the mental health system to meet her needs on going into the future.
Thank you. And was it a determinate sentence case, or what happens when Jane turns 18?
Excellent question on this. And there's a strange area in the law with determinate sentence cases and even potential certifications. Certification, if the case was started before the child becomes 18, typically if you've been through anything under Chapter 55, once they age out at 19, the case will end. They may be transferred over purely to the adult mental health system. Similarly, on a determinate sentencing case, if the state did not pursue a determinate sentencing case before the child aged out, then they would be barred from pursuing it, as at that point the child would be facing a stricter punishment than they could have faced while they were in the juvenile system. Under the family code, a child, once they age out, faces whatever punishment they might be facing under the juvenile justice system. So if a determinate sentence was not started before, the maximum would be confinement up till age 19, which at aging out becomes a moot issue.
And is there a transfer to an adult court of that child's case if it was filed by the prosecutor as a determinate sentence case?
Yes, if it was filed beforehand, then it would be transferred to an adult court following the same transfer proceedings as any other transfer under a determinate sentence.
Okay. You're getting several questions in chat. If you want to respond, one of the questions I think that came up over the course of our preparation is Jane eligible to seal her case?
Assuming it was not a determinate sentencing case, then Jane would be eligible to seal it once you meet the other sealing requirements. Going into one of the questions I see is dealing with the waiting list for a child going to a state hospital. We've dealt with this more in the context of our local mental health authority, but still dealing with inpatient treatment. The discussions I've had in representing my kids like Jane were that the Chapter 55 says that dads or dishes, in this case would be Department of State Health Services, shall provide a placement for this child. And so the stance I've taken in discussions is this is a requirement. This is not a waiting list issue. There are others that may be a waiting list issue and that a bed has to be found. In some cases, that means they may start off with a local mental health authority. We do have a local state mental health hospital here in El Paso, and then maybe subject to transfer to one of the other state facilities later on. But again, when you're dealing with a child with this level of mental health issues, they really need to be in a proper mental health environment.
I was just going to add that in my jurisdiction, the less than a handful of cases, the child was so severely ill and such a danger to the victim in the case, who also lived in the home, that it was clear to everyone that she had to have inpatient mental health services immediately. And so getting back to your differences between, I think there's a lot of questions in the chat that are really important. One is, can a juvenile authority invoke 55B for CHINS cases, for child in need of supervision, and not a petition case?
And I was looking at that, and I'm running through Chapter 55 in my mind, and I can't think of anything that would prevent Chapter 55B or any part of Chapter 55 being used on CHINS cases. And again, when you consider that, I believe the intent of Chapter 55 is to divert children with serious mental health out of the juvenile justice system, I think it would absolutely be the legislature's intent to invoke it, because a child in that situation, again, needs treatment from the mental health side before we even try to address any further issues.
Getting back to whether you file a Chapter 55 or a Chapter 55B, I think there are some questions in the chat that indicate that we would like to know what goes into your decision-making process. So lack of responsibility, as you stated, gets into the facts of the offense. So can you talk about some of those analyses you make?
Typically, again, I start out with a fitness to proceed, which is a 55C, and see where the child is. Because, of course, before we can get to how they were doing at the time of the alleged offense, we've got to deal with where they're at now. Are they able to communicate with us? Are they able to assist in their defense? Now, at the same time, I'm looking at, does it appear there's lack of responsibility? And one of the beauties of the juvenile justice system is typically we have seen a child come in within a matter of hours or at most days from the date of the alleged offense. And we've got a lot of the information that for adults is all too often lost. There are the initial assessments on the child coming in, especially on an in-custody referral to the juvenile justice system, which help really fix what the child's situation was. Were they in some type of extreme condition? Were they in crisis? Were they truly not able to conform their conduct? Were they even aware of the consequences of their conduct? And it's one of those where things that frequently as a defense attorney make me cringe with what our kids will say as they're coming in through intake and talking to the department also can become absolute diamonds for protecting that child moving forward, because it's absolutely documented there. And I'm, of course, going to be continuing to get the mental health records and everything I can from the family. But I think if the child's not fit to proceed now, they're not even going to be able to, from a assessment and evaluation standpoint, be able to talk to a mental health practitioner to get fully evaluated as to whether they lacked responsibility at the time.
So one of the things that I think everyone wants to know is, we've all been told that we had to be on a waiting list for the 90-day placement. Can you just go into a little bit more specifically how you enforce the shall provision of the 55B versus the routine fitness or lack of responsibility?
And what I've done is, I start drafting the 55 commitment order to track that language that says the director of the Department of State Health Services is ordered to provide a placement. And then I serve that both going to the department in Austin. I serve it on our local mental health authority. I serve it on our local state mental health hospital, so that it puts them all on notice. And typically between them, we at least in my experience, have gotten to bed very quickly. The biggest challenges I've run into is not so much the initial 90 days, is on the extended placements, especially on long-term competency cases where we're dealing with ID issues, where it's the child has been there, they've come back, and trying to get back in to, because typically when they get sent back after the initial period, we've lost our bed. And then getting that bed again frequently becomes far more challenging.
Exactly. And to the issue of expansion of Medicaid, I actually don't have any information on where the legislature is going with that. I didn't know if you had any thoughts that you would like to share.
I don't. I would absolutely like to see it expanded to take care of our kids because, again, the more we can treat our kids and address their issues prospectively and deal with their mental health issues where they are now before there's a chance to deteriorate further or develop issues where we have dual diagnosis or other challenges, we leave our kids in the best position. And so, one thing I was seeing on the chat that I think came from a member of the judiciary that highlights probably one of the biggest challenges for everybody dealing with kids with serious mental health issues is frustration where the court's feeling like there may be an issue, but there's nothing coming from the attorney. And so before getting straight to that, I want to step back some to some of the challenges as a defense practitioner that come up that we haven't talked about. We've talked about the family's frustration. They may be at their wits' end. They may feel like they are unable to provide further. They may be afraid for their safety dealing with whatever issues this child has. And they may even be told by some of the mental health practitioners they're working with that going to the juvenile justice system is the next level of option to seek assistance. And one thing as a practitioner, and I frequently talk about this on Fitness to Proceed, is the last thing everyone who's a parent knows. They do not want to hear, no matter what they know, that their child has a problem. They don't want to hear their child is not functioning like other children are. I think of parents who've told me, he'll get it. Just explain it a few more times. He just needs more time to get it. You just have to keep telling him and he'll get there. And so there's also where we all laugh about we're licensed as attorneys and counselors of law. But this is where a lot of the counseling comes in, helping the family to realize that this is not something negative. In fact, I've also seen it with opposing counsel who've said, I don't want to tag this child, especially on ID cases, as being a big dumb kid. And a lot of Chapter 55, whether we're talking about Chapter 55B, our fitness, or we're talking about lack of responsibility, can be the key for this child to receive services for the rest of their life. If it's intellectual developmental disorder, getting that diagnosis of developmental disorder will open the door to services for the rest of that child's life. Locking in the mental health diagnoses, even though they may change as the child gets older, again, will help them to access the services they need. And helping the parents to understand that we understand their frustration, but this is necessary to take care of their child and for their child to be in the best place possible, not just now, but long term. And then ultimately, I think this is part of the reason, going back to the question from the chat, that the family code does have the number of options for who can file. The court does have its own option to file sua sponte on Chapter 55 issues, and that opens the door to go forward. And then, of course, once the proceeding started, it's a bit of a gray area. I can't imagine the court having the burden to prove it up at the hearing. But from that standpoint, the court can set the hearings and move things forward to be sure the child's needs are addressed. And it's probably a good way to come back to Jane and go through that she had other challenges and that she was being raised by a grandparent and getting assistance. She was able, after a long period of time with mental health services, to get out, go back home with her grandmother. And the last I heard, she was doing well. I certainly hope so. But again, I think this is why Chapter 55B was created, so that we do not take a child who is in extreme mental health distress and place them in even a rehabilitation focused punitive approach, which ultimately is what you get to if you're looking at TJJD as the ultimate sanction, because it has severely limited mental health resources. That child needs to receive intensive inpatient mental health, and that's what Chapter 55B is the vehicle for.
Thank you, Bill. That was excellent. And just to reiterate an important point, among many important points that Bill has made, is that these diagnoses have to be made before the child reaches 18 to access more easily the services that they are no doubt going to need for the rest of their life. And that I just wanted to reiterate that very important point for all the juvenile practitioners and parents and other care providers out there, that your diagnosis of mental health, of intellectual disability, and of developmental disability will absolutely help the child throughout the rest of their life if you can get that done and assist in getting that done before their 18th birthday. Any other parting thoughts, Bill?
The only one actually be to reemphasize that it could literally be a matter of missing out for the child in the case of intellectual developmental disorder, because it has to be diagnosed during the developmental period. We're there in the juvenile justice system. And I hope this helps to help some kids out of being in a very challenging place and to succeed and have productive lives.
Thank you. Bill is a statewide expert, and he is going to provide to Molly Davis and Christy Taylor on the JCMH website his proposed orders that he serves when he has that super priority placement order, and that he serves on all the various agencies. He's going to provide that generously to us. And thank you so much for your talk today. And thank you all